Thank you very much.
Thank you, Ms Moore.
Good afternoon, Chair. We continue the evidence of Ms Molyneux.
Thank you.
We were talking before the lunch break about Rule 35, and now I want to ask perhaps a quicker topic, as we've already covered it in a little bit of detail with Ms Colburn. That's Rule 40. And I just want to ask about one element of compliance with the requirements of Rule 40, which I asked Ms Colburn as well. And you cover in your witness statement at page 26, and you say it wasn't possible to visit all the detained persons on Rule 40 and also Rule 42 within 24 hours, although you were aware that it was a legal requirement to do so. Is that the case?
Yes.
Did that change, or is that still the case?
That's still the case. I think, though, certainly, and you mentioned, I think, a dispensation or something, that hasn't been sought, but the Home Office is aware of this, and in fact, there's a proposal going back to, my recollection, late 2018 work started, but certainly 2019, that the detention centre rules be changed, and that the IMB would visit as part of their rota duties and more like in prisons. But no, the practice is as it was in 2017 still.
I also asked Ms Colburn about whether there was any analysis or monitoring of the kind of underlying factors that led to Rule 40 being invoked. Do you recall any different from her on that?
Well, I think we actually do. You know, the first thing you know about a Rule 40 is you'll get a call from the Oscar if you're on duty. And certainly now, and I know we've had an internal training session on this recently, you know, that is a chance to at least ask more about, not like, oh, there's been a Rule 40, it's okay, who was on it, what happened, why was it, anyone hurt, how. So that's the beginning of information gathering. So if you've got particular concerns, then if you're on site and you see the man, you get his view. I would say, though, no, not, I wouldn't raise it to the level of analysis, but there is certainly more information gathering or trying to understand what's happened, yeah.
So asking for more information is one thing. Do you ever recall seeking to challenge whether a Rule 40 or a 42, or indeed a use of force, was that was a correct decision to make? So saying, I don't actually think that this should have led to a
certainly
Rule 40.
recall questions about probably more Rule 40, and certainly now, and there are very live issues still at the moment. There are a man who's been in and out of CSU and on E-wing on Rule 40, and we've been raising issues about that. So that's an indication of more recent practice, I think. I'd say we do it more now.
Who would you raise such concerns with?
Well, the recent example, I picked it up at a board meeting as well as the adults at risk meeting, so it's been raised, yeah.
So turning to adults at risk then, and vulnerable people generally, I want to ask about a couple of specific individuals. You say at 146 of your statement that post-Panorama you looked back at some events, but I'm not sure which, so perhaps you can tell us about these events and whether they're things that you've reconsidered. So first is D1275, and you may already have heard about him in the course of the inquiry or recall him yourself. You've also been provided with a summary of his period at Brook House within a statement from Dr Bingham of Medical Justice. The whole thing's over 3 pages long. I'll give you a brief summary of it now as well. So he presented on arrival on the 1st of May 2017 as very preoccupied and acting inappropriately, saying he was hearing voices and repeating, "They will find me." There is a spice overdose, which is what was shown on Panorama. After that, he was placed on E-wing. The DCO noted that he didn't seem to understand what was being said, and despite mental health referrals, healthcare discharged him from their service for non-attendance. His solicitors got him a psychiatric report which said he had bipolar or a psychotic illness and lacked capacity, and then the next month Brook House also arranged for a psychiatric assessment which said effectively the same thing. If you can recall, did you know about his case at the time?
Now I know his name and I've seen him on the command, but he's not. I don't have a particular recollection of that detained man or his case.
Do you think now, knowing that you do what you do now know about him, that you should have been aware of his case and the particular concerns, particularly about capacity?
I think now there is more information generally because of adults at risk, vulnerable residents meetings. You know, there wasn't even an adults at risk log before. So I'm just hesitating here because how do you even know about him? If there was an ACDT, yes. There is more information generally now. My only hesitation is about what should have happened then, given the information known, I don't know.
Well, actually, you've preempted my next question,
Oh.
which was going to be, well, how do you learn about these people? It requires, doesn't it, somebody flagging them in some way, so either
Yeah,
by making them an adult at risk or
yeah,
by...
or an ACDT or something,
Yes.
and then you look at it and follow from there, but yes.
Is
yeah.
there any other process by which, for example, if healthcare record particular types of issues like capacity or these preoccupied and inappropriate comments, that could be somehow escalated to the IMB without it being through a formalised
No.
process?
I mean, we do now. I've had a couple of questions that I call from GDWG about people, men that were concerned, there were capacity questions. But otherwise, it is hard. How do those people come to your attention? No, there's no particular way of flagging. Other through, as I say, now adults at risk is a much better way. Yeah.
And you've again been referred to, particularly in the context of adults at risk, the case of D2159. So despite, as I understand it, recommending improved multidisciplinary coordination over adults at risk in the IMB's 2017 report, is it correct to say that the understanding of adults at risk remained an ongoing problem during the relevant period?
During the relevant period, absolutely. Yeah.
That, in having heard the evidence that you've heard, does it remain an issue now?
Oh, it's much better now. I look during the relevant period and even after. Even when, and I put in my witness statement how there just weren't meetings, there wasn't information, the right people weren't attending. Even when that improved, we still had concerns and raised. I remember speaking to the head of safeguarding at the time that frontline staff don't seem to know that men are on the adults at risk list. So how are they going to care for them? And there was a response, well, that's kind of confidential information, but they're meant to be looked after. So I think that's moved on. I think there's much more awareness now, frontline staff. On this meeting I keep referring to, the vulnerable residents / adults at risk, which Serco has introduced. Welfare comes, particularly officers from the wings come. There is much better awareness now in the centre about adults at risk, and yeah.
So I mentioned D2159. He's a detainee who you do mention in your statement at 110. So he was severely weakened by food refusal, and he was moved to E-Wing under restraint on the 10th of April 17. You had contact with him in a statutory visit in April 2017, which you deal with in passing at 110. Yeah. There's much more detail there in the report, including that you'd attended with him, I think, a doctor's appointment. Yeah. He spoke briefly to the doctor, appears to hear, because he responded to the doctor's request to squeeze hands and poke out tongue, but wouldn't engage, and he looked painfully thin and very weak. You mentioned his case in your rota report for that time, which you quote as well in your statement, saying quite a few issues related to D2159 and to D1255 under adults at risk DSO, highlighting the need for clarity on accountabilities and multidisciplinary approach between Home Office, G4S and healthcare. So you knew at that point that there was a need for clarity in the approach between the parties, between the Home Office, G4S and healthcare.
Yeah, they just didn't appear to be working together in some cases, yeah.
You've highlighted some pretty serious concerns, obviously, about this man's state as well. So it's one thing to say that adults at risk, approaches need to be changed, but is there anything else directly that can be done when you see somebody in this situation?
Well, why is he in detention? To raise that. Is that what you're asking? But yes, that would be... So yes, you're raising the systemic or structural issues, but for this individual man, yes, why is he in detention? Why isn't he released?
And is that something that you recall raising in relation to D2159 at the time?
No, I don't. I think that's probably something that's changed, but no, I don't recall asking that. It might have been in a conversation, why is he still here? I do remember going in with the GP and why is he still here? But that's a different... I'm not going to say that's raising it formally, yeah.
And it sounds, perhaps, but correct me if I'm wrong, that you feel like you might take a different approach now and ask a more direct question about why someone like that is being detained. And who would you ask that to?
Well, the example I've just given of a few weeks ago, probably last week or maybe the week before, it's, you ask the people you ask Home Office, because it's a Home Office decision on detention, and you can ask Healthcare for information, but ask local Home Office, and then you raise it at board meetings.
I want to ask about safeguarding issues generally. So you make a comment about them at page 48, paragraph 132, in the context of working with DWG, who we'll come on to in a moment. So safeguarding referrals, and you also mentioned that GDWG continue to let you know about people that they're concerned about by way of safeguarding, as I understand it.
Because I'm not chair, their contacts are with the
I
chair,
see.
but yeah.
And you say that they're an example of an area where we need to work together.
Yeah.
You say at the meeting of 24th of February 2021, I raised the point that Serco must be the first and primary point of contact for safeguarding concerns. And this is because the IMB is comprised of volunteers and doesn't have the resources to be in the centre as frequently as it would need to be to deal with all the safeguarding concerns, and you might not pick up emails as urgently. So the IMB 2020 report in relation to safeguarding under the subheading, which involves safeguarding at paragraph 4.4, said that reviews of adult at risk, ACDT and Rule 35 procedures all needed review, but this had been paused by the Home Office despite your recommendations in the previous year's report. Do you consider that Serco and Brook House more generally is dealing with safeguarding sufficiently well that they should be the first point of contact for safeguarding concerns?
Oh, sorry, what I was getting at here, it was purely a risk issue. It's like, no, it wasn't don't come to me with them, but this was just on my personal phone. If I'm not picking up, if I'm on holidays, no, that's all it was. If they had real concerns about the safety of a man, that was all it was. But also copy me, but no. And for example, there is another instance I mentioned where GDWG have come direct, where yes, you're not going to refer if somebody's got concerns that G4S or Serco is mistreating me, then absolutely. That's not the right place to go. They will come via us. So no, that was purely a more, I might be on holidays. That's all that was. Yeah.
And just staying on safeguarding for a moment, do you consider looking at firstly the relevant period that the Home Office had adequate oversight and powers in relation to safeguarding of what was going on in the ground at Brook House?
Well, when you look at, the most obvious sign of safeguarding for that time would have been, is there an adult at risk? And that wasn't happening. So, G4S wasn't doing it, healthcare wasn't doing it, Home Office wasn't doing it. So at that time, that would be an indicator of problems, that wasn't happening.
Is the proper processing of Rule 35, particularly 1 and 2, also an aspect of safeguarding?
Absolutely.
And that also wasn't being done, you've already said. What about now in relation to the Home Office's role, not realising or not taking up the fact that Rule 35, 1 and 2 reports weren't being done? That remains the case now, doesn't it?
Yeah, and I was very surprised with Sandra Culver's evidence that she said Home Office, I don't know who, but some Home Office people were involved in some of these forums, which I don't know if that explains why also the Home Office were never responding to our issues about why aren't there any, but there's something is amiss there, yeah.
And just in that paragraph I read, 132, you also just briefly, incidentally mentioned that the IMB are volunteers. So you said, your phone might be off, you're not there full time, etc. And I asked Miss Colbrand about this in light of Professor Bosworth's suggestion that IMB members be remunerated. And Professor Bosworth also refers generally to a professionalisation of the role. Do you have any views about that? Not just about safeguarding, but more generally as to the IMB?
I think, well, to be perfectly honest, I'm not sure that I'm the right person to ask about this. That is something I think more of a national level, for the management board, Dame Anne Owers and others have given it a lot of thought. I have said, though, I hadn't given thought really to the professionalisation. I think there are probably dangers with that. It becomes a job and then it doesn't change. But to attract a broader, to reach a broader range of people to become IMB members, something should be done. And whether it's, I think, as I suggested, I wasn't aware, for example, even the current expenses or reimbursement policy would do more than travel. Now, that's a starter, but I don't feel qualified to talk on a broader level, on a higher level. Yeah.
And as to your just experience as a chair and along with your members, what would you feel about the promotion of former detainees being made IMB members?
We should be open to that. Yeah.
I just mentioned GDWG there. You've done a fair bit of reflecting, it's fair to say, and you conclude in your paragraph 126 of your statement, on reflection, I do accept that the IMB was too affected by managers' criticisms of GDWG. And managers, is that both Home Office and G4S or one
Yeah,
in
it'll be both,
particular?
yeah.
You've listened, I believe, to the evidence from those from GDWG who attended to speak to the inquiry, as well as Ms Colburn's evidence on it this morning. And you may have heard the live witness we had at the start of this phase. You mentioned that you think you'd met him as well. He told the inquiry he was really suffering, he wasn't getting any visits, and he talked about being allocated a GDWG visitor. He said, this lady came to visit me every single week. They had a dog. She was so good to me. I was so looking forward to it because it's the only ease from the detention centre I used to get. He said they're still friends today, he's friends with her family, and they really helped me out inside there. Obviously, IMB fulfills a completely different role to GDWG. You're not a visitor to detainees, but you, of course, would see their value, wouldn't you?
Absolutely. That's why I say I see it as complementary. They have something we don't. They have continuity, with particular men. We don't have that. We come in. That's one aspect where, when I say complementary, the different perspectives, I think, work together more. Yeah.
And looking back, as well as reflecting on being too affected by managers' criticisms, do you generally regret the attitude that was towards the GDWG by IMB at the time?
I do. I think it's important that I say that we were really trying to help because we knew they were having difficulties getting access or issues with the centre, and that was why, as I think I said, there really wasn't a relationship. They would ask for something, we would respond. But so it was always well intended. But yes, we should have been able to form our own views and look at what these people offer. It can be complementary. So yes.
And rather than go back to everything that led to that situation, the inquiry is more interested in how a healthier and more appropriate relationship will continue in the future. So can you tell us about any specific plans or progress in working with GDWG that the IMB have taken up?
Well, I think it got to a point where, at least now there's the basis of a foundation. That's what it is. We both have work to do. We probably still, to be honest, have more work to do because we've got to overcome, understandable mistrust. I think there's also not a real understanding of everything the IMB does. So we need to work on that. So, and yes, the current chair leads it now, but I've had discussions with him because we have our next meeting coming up with them. I think it's next week or the week after, and thinking about, well, what do we do next? And some of it will be, let's just talk. Okay, we've got a foundation. Let's talk how we think we can really work, rather than this. It's still ad hoc in a way, even though there's set meetings. So yeah, we've had discussions about that, and we'll be taking it up for the next session with them. Yeah.
I want to turn now to post-panorama, although we've obviously already touched on this because you've helped us with the old versus the new and how things work now. But specifically in the immediate sort of post-panorama period, you set out your immediate reaction to the broadcast at pages 52 to 53. So you had some advance notification of the allegations, but watching it itself, you said, described making you feel physically sick, and you said, while you thought you'd reported on some of the issues that would be shown, like the use of spice, when watching it, your overriding feeling was guilt and fear that we might have missed something, especially the abuse. Yeah. And you say you felt ashamed to be associated with Brook House.
Yeah.
Tell me if this is an unfair or inaccurate summary of what followed, but your view, I think, and that of the IMB was that while you'd reported on many of the issues showed, what the matter that you'd really been taken by surprise was the abuse.
Yeah.
Does that mean that your actions which followed, including when you took over as chair a few months later, were focused on detecting that sort of mistreatment?
That was one of our prime, we do monitoring priorities where you focus on a number of things, but absolutely trying to, the risk is still always there. It's not going to happen in front of you, and we've heard that from so many people in evidence. It's going to be hidden, but knowing that it can still happen again, what do you look for, what do you, and that is just, I would hope it's almost a second nature thing to IMB members at Brook House now to have to keep that in mind, but keep learning on it. But yes, absolutely.
And you mentioned your priorities. If we could just have on screen IMB 000203. Again, this is just your statement, so it's page 53 if you want the hard copy instead. this shows at paragraph 149, it seems to be a sort of the list that you just referred to there, your post-panorama priorities. So 53, please. And the first there at A is how to monitor staff culture and behaviour, particularly in respect of actions and behaviours that might not be performed, as you say, in front of monitors. So that's something that potentially you didn't realise during the relevant period, how ingrained and extensive poor staff culture was. I'm quoting from your witness statement there. How are you able to actively monitor this now?
It evolved. It went from something very basic to just, I think I probably mentioned there, we'll be, when we're in the offices looking at ACDTs, you sometimes weren't noticed and you could hear conversations. I think, and struggled with how we do it, but there was an IMB National Study Day where Dr. Hinpal Singh Bui spoke about it, and I think it drew on some of the work of Professor Bosworth too, and it was off the back of that I felt that here was something we could use, and we came up with that. Look, some of it maybe seems obvious now, but just language, desensitized language. Is anything being done about trying to develop staff culture? You're seeing spikes and things. So we have that working list now. Yeah.
I asked Ms. Colburn earlier about staff complicity and the idea of kind of closing ranks, and we discussed, it's just 1.0 in SIRED, whether she was aware of the reasons for his absence, and she said she doesn't know if she was aware of why he was absent for so long. Do you remember whether you were aware of that?
Yeah, I have to say I thought the time when Mr. SIRED was off for quite a while related, at least the one I'm aware of, was there were just some personal health issues.
You didn't understand it to be related to things that had happened in the centre?
No, no.
Okay, and then you discussed there the issue of IMB's independence and perceived independence, how better to monitor the impact of policies and actions of the Home Office, and what we'll come to in a moment is the letter that you sent in 2020. Is that an example of you bringing into force this plan of better monitoring the Home Office?
Well, that's an extreme example. I mean, you hope you never have to get to that, but I think generally, we don't see the contract. I don't think we need to see the contract, but sometimes that could be a veil, really, and you tend to always look at G4S, but there's a realization, actually, no, you have to look at the Home Office policies and things too, and the impact. I think it's just a much sharper focus, but yeah.
And monitoring, use of force and its governance as well, and that's done, I believe, through the different kind of levels of scrutiny meetings now, is that right? Yeah,
I think it's something, and again, I've mentioned this to at Daymanos and at a national level. I think there is a need for some guidance on what IMBs can monitor in use of force. We're not CNR experts. I don't suggest we should be, but we look at use of force reports. We look at them all the time now. We make sure the governance meetings are working. But I still think there's something where a little more could be done, a little more guidance. But yeah, that's an ongoing thing. Yeah.
Thank you. I don't need that on the. Actually, sorry, I did need that on the screen. Do you need the reference again? It's 203 at the end. Thanks. I want to turn now to discussing your most recent reports. So page 57, please. So the two recent reports from 2019 and 2020, you were chair when they were written. You've seen other witnesses perhaps being taken to them. And your quite pithy summary is at 162 there. You say that you believe your focus sharpened after Panorama and there's been a fundamental change in approach, and that's evidenced by findings and recommendations in 2019 and 2020 annual reports, which included criticism of the pre-Brexit charter flights, failures in the adult at risk policy and Rule 35 policies and practice, Home Office debt staff not serving removal directions in person during COVID pandemic, and delays relating to providing bail accommodation. Can I ask, have you felt the effects of that change in approach? So you can make stronger criticisms and recommendations, but is there any change in what comes back to you afterwards?
I think local Home Office people on the ground, yes. But when you're talking about trying to get change policies and adults at risk, frustratingly no. And it'll be in the annual report again this year. And I think it's the same thing, issues we see NGOs having with them. But we will keep coming back. It needs to be looked at, yeah.
And at the next paragraph there, starting at 163, you mention a letter that you sent on the 2nd of October 2020 that I've already alluded to. Can we have that on the screen, please? It's DL 0000140, and it's starting at page 113, please. So this is a letter, just while it's loading, that you sent to the Minister for Immigration Compliance and the Courts on the 2nd of October 2020, and it's co-signed. You're one of the signatories.
Yeah.
And it's headed Impact of Dublin Convention Charter Flights on Detainees. You say there you're writing to alert to the concerns of independent monitoring boards about the impact of charter flights. You mention there the requirement on you to bring certain causes of concern to the attention of the Minister. You say, by way of background, on the 12th of August 2020, the Home Office began a concentrated programme of charter flights to EU countries, party to the Dublin Convention. And the IMB findings there, our evidence indicates that a series of issues are collectively and cumulatively having an unnecessary, severe and continuing impact on detainees. And at the bottom of that, the cumulative effect of those concerns amounts to inhumane treatment. The second page goes on to detail the nature of the concerns, and it's very detailed, but in summary, there's a large number of vulnerable detainees generally at Brook House, you say, many of whom are at risk of suicide or self-harm. There's constant and high levels of stress in the population more generally. A further negative effect resulting from the concentrated nature of the charter flights. You mention the Rule 35 safeguard and the 60-person backlog. You discuss at the bottom of 2 an overleaf actual self-harm immediately before removal, giving examples of a man who poured boiling water over his legs, others who were taken to hospital due to self-harm but immediately removed upon return to Brook House. And you also note a lack of information about the receiving countries. Now, the places they're going to aren't their countries of origin, are they? It's an EU system to determine which member state hears the application by the asylum seeker. And you say that the lack of information about those receiving states was adding to the anxiety. And you go on to say at the bottom of, so on the next page along, please, that we are raising these issues because of our concern about the actual and potential risks of harm to detainees, and you ask for an urgent response. And we see then at the bottom of the page, as well as the Minister who it went along to, so various people from the Home Office effectively. If you just would scroll down slightly. It's a big CC list there. So people from the AMB and also people from the Home Office. Did anyone from Serco see this?
I sent it to them after we'd sent it. I said, for your awareness, I sent it to the director, and I think I sent it to local Home Office people after it went,
And then for the sake of completeness, the last page, 116, gives some graphs which show the increase of men on ACDT or at risk if removal directions are served, the men on food and fluid refusal, and then the top detained nationalities. And looking at those nationalities there, are those people in general across the channel in small boats? Is that the same?
Yes. Asylum seekers.
And they're asylum seekers, which is why they're being removed under Dublin for determination of their claims. You got the response on the 25th of November 2020. Can we see that? It's at IMB 00206. And you say you don't consider it answered your letter in a meaningful way. It said, I won't go through it all because it's, again, quite long, but to summarise, and I'll have the whole document adduced. It says that the charter flight programme was to give effect to Dublin 3. It says that all incidents of self-harm are treated very seriously and every step is taken to try to prevent incidents of this nature. As you will be aware, it says, there are established procedures in place at every IRC and short-term holding facility to minimise instances of self-harm with formal risk assessments on initial detention and systems for raising concerns. So pausing there, it says there's established procedures to deal with self-harm. Were the established procedures at Brook House during this period sufficient to try to prevent the levels of self-harm here?
Well, clearly not. Look, the levels, they're not coping.
And why was that?
Well, I think the characteristics of the men, the vulnerability, and what was happening to them, it was something wasn't working if there's that much self-harm,
And it goes on to say overleaf that these people are in the UK illegally, just although it had said on page 1 that they were awaiting determination of an asylum claim. That's obviously why they came under Dublin 3. And as to Rule 35, it says this does not determine removability and there's no specified time within which a Rule 35 assessment should be done. However, it says there is a time limit under Dublin 3. Did you understand this to mean there's a window of time to remove these people, so it has to be done with some expedition?
Yeah.
And that, I suppose, would have been the end of December
And
2020.
Brexit was coming, and there'd be no right to do it after that under the convention.
Can't take part in EU schemes after
Yeah, it
Brexit.
would fall away.
That was the 31st of December 2020. Then it goes on to say at the end that the asylum system is broken and that these people are in the UK illegally, and we continue to seek their removal with appropriate safeguards in place. And you've already said you don't believe that appropriate safeguards were in place at the time. And whose failure is that?
Whose failure? Sorry, do you mean just generally about what was happening at Brook House then?
Yeah, the failure that even despite the appropriate safeguards, you still had these concerns.
I think the problem was, it's more that the Home Office kept bringing these men in. The Home Office were aware of the problem. So when a safeguard failures, it was, and when I said overload, the Home Office knew this was happening. This wasn't the first they'd heard of it. You know, they had heard, the minister, by they I mean senior people had heard. I know they had heard from Serco concerns about the numbers and the numbers of self-harm. In spite of that, numbers kept coming through for these charter flights. And, you know, it's not so much about process. Our letter was about the impact. It's headed the impact. It's all about what is happening to the people. We were not challenging particular processes or saying you cannot remove people under the Dublin Convention. This is what's happening. And at the last, you know, it was a concern about safety, that there is going to be more of this if you persist. The reply is all about process. We have the right, we have the process. So there's just a total disconnect and not, in my view, acknowledgement of the problem and the issues we had raised.
And I understand on the same day, I think, that you received this letter, you gave evidence to the Home Affairs Select Committee.
Yeah, we wrote a letter asking for urgent advice, not advice, urgent response. We didn't need advice, urgent response. There was nothing, not even acknowledgement. I mean, I knew they had it because we'd copied enough people. And then I think it's only 6 weeks later, this response comes in. And I don't think it was coincidental that it was received on the day that we were to give evidence before the Home Affairs Select Committee. My assumption, I don't know the facts, my assumption is that was done, or one of the reasons that would be done, so as if we were asked, we had a reply, we couldn't say no because we had a reply. That may be unfair, it may be inaccurate, but that was the perception I had, impression I was left with.
And Ms Molyneux, what else can you do, if anything, as the IMB, once you've invoked your duty under Rules 61, 3 and 5 and then received a response like this? Is there another, obviously you gave evidence to the Home Affairs Select Committee, is there anything else you can do, or is that the limit of your powers?
I suppose given the nature of the treatment, you have to think about human rights aspects. I think practically, I think it is the limit, but I think even if you get a response like that, it doesn't take away from the fact that we should raise issues like that. We would continue, and it raises awareness. So, yes, of course we would have preferred a different response and action, but there's still value in doing it, and we'll continue to do it if necessary, yeah.
So the last real topic I want to ask you to consider is an article that was published in the Observer on Boxing Day. It's at INQ 000115, Boxing Day 2021. Did you read this when it was published or thereabouts? I
saw it soon after. Somebody brought it to my attention, yeah.
And it's based upon 180 documents which were obtained by the... Stop. If we just scroll up to the top bit there, thank you. Didn't realise it would show up like that on the screen. It's based on 180 documents. It doesn't matter, we won't be able to read it. I'll summarise it for you. Obtained by the Observer and Liberty Investigates. And it notes an uptick in the use of force around the charter flight programme, which we've just discussed. It also shows from the material obtained that there were 98 use of force reports completed by custody staff between the 1st of August and the 31st of November 2020, at a time when the population was only about 100. Have you seen that material, the use of force reports? Presumably they'd be the ones that would come to you generally anyway.
Have I seen the underlying use of force reports? Yeah. Certainly at that period of time we were, we've had these patchy periods where we hadn't had use of force reports, and there probably was still some difficulties getting them then, but so I couldn't say we'd seen them all, and no. But certainly would have seen some, yeah.
I don't need exact figures, of course, but does that number, so 98 use of force reports during that period, accord with your understanding of how frequently force is being used generally?
Well, I think those numbers maybe come from our annual report, and there's some analysis that we did. We just get the raw numbers and then we do the analysis. It's more on a prevalence basis rather than the numbers. And it's high, self-harm, prevention of self-harm, and when you look at other years, yes.
And there's complaints about excessive use of force mentioned in the article, and Liberty, I believe, obtained 17 staff complaints submitted by Brook House staff and detainees about staff behaviour between 20th of May and the 31st of December 2020, and 14 responses by Serco. Would you have seen the complaints and the responses?
We do see, the chair sees copies of all, so if it is a complaint in the sense of a formal complaint, the chair does see all of those. The Home Office clears the boxes each day and they automatically copy the IMB chair on all complaints picked up, as well as, sending off to their central thing. And so I've looked back. I mean, I kept a rough log. I'm not quite sure what is it complaints about pain-inducing techniques or...
Some of them are, yeah. They are summarised in the article. There's a number of complaints about staff behaviour generally.
That's what I did look back through the log I had kept when I was chair, and I didn't see. So I see. I'm supposed to see them all. I believe I see them all. I don't know if I was looking for wrong themes. I didn't see a particular cluster or anything like that. But I should have been copied as chair on formal complaints. Yeah.
And I believe that the inquiry has received that underlying information as well. Finally, discussed in the article is the emergency dispensation for people without updated use of force training refreshers, completing nevertheless work at Brook House. Were you aware of that process?
Yeah, yes, I was. I'm not quite sure where I heard it, either at a board meeting or perhaps more likely there still are COVID calls, about impact of COVID a couple of times a week. And I think I may have heard it there. So anything, and the reason was, if you look at the timing, March 2020 was the first lockdown, and Home Office, we were told that had given dispensation because with the rules then you couldn't do close contact, and that would have been necessary for the refreshers. So that's what drove it, yeah.
Did you raise any concerns about that, meaning that people would be out of ticket?
No, I didn't.
And looking back, do you still think that the COVID dispensation reasons were adequate reasons to have people who were out of ticket?
Well, I think that is probably a question for the Home Office, in the sense that if you're going to keep a centre running, that you need to have people prepared to do, use of force. So they would have to, I suppose, if the decision is made you're going to keep a centre running, you're going to end up with some people out of ticket. But, yeah.
And finally, I appreciate, you can take that from the screen now, thank you. You've been listening to a lot of the evidence in the inquiry, Miss Molyneux. You've seen documents and you've read the expert reports as well. And I didn't ask this of Miss Colbrand simply because she's no longer part of the IMB. We may have already covered everything you want to say, but I just wanted to ask if there's anything we haven't yet covered today, which to you is either a real source of current concern for the IMB or a really important action or goal which you think it would be relevant for us to know about. Would you like to share those points with us now?
Yeah, look, the biggest improvement and the biggest change is there is now a contract that requires much larger number of staff. So that is a plus, but there are still issues even now. Serco, and they're very open about it, each board meeting and report, they are beginning to have retention issues again as the airport reopens. Also, the centre has been running at under half capacity because of COVID restrictions. Numbers are going to go up. Serco, even if they're fully staffed, have a lot of highly inexperienced staff under those conditions. So that is a concern. They acknowledge it. We're talking about it. I think we have in our annual report this year, there are the same things about the need for a review of Rule 35, and particularly in light of this and adults at risk. Also, we, in the last year, have seen increasing problems, we think, with the detention gatekeeper not working. There are too many people coming in who becomes apparent very quickly have serious mental health problems. And I already touched on one of the concerns that, CSU and E-Wing are still being used for those. So those are issues. I think also yes, there are some also The accessibility of the caseworker I've already touched on. I think that's become really exacerbated with COVID when the detainee engagement team also wasn't as accessible. So there are also concerns about case progression or lack of it. There are significant numbers of men who appear to be stuck in the system, and you will ask, what's the realistic prospect of removing this man anytime soon? And I'm not sure what it is, whether they're staff shortages or it's a change of policy. People seem to be stuck in there longer, significant numbers of men. I think we have a couple of new issues this year too. We do not think the complaint system, as it's working on the ground, is fair, and we suggest that, or gives confidence it's fair, and we suggest the Home Office needs to really review it. I think, the warning sign is it's about 13% success rate for a number of years, and you start looking, and I think there are issues that it takes too long. It can take 20 working days, but also there are some fundamental issues that the people who are investigating the complaints are also Serco staff. So in terms of a perception of fairness, and also we see a number, too many, enough to make us concern, responses that seem too technical and contorted, and perhaps, I don't know what the contract says, but there's a sense is maybe it's driven by penalty. So we've raised that this year, and that will be an annual report. And there's a serious problem, we think, of being confident there's access to meaningful legal support, in the sense that mobile phone signal has been a problem for years at Gatwick. Finally, there's been an audit, and it knows it's a serious problem. And there's currently, money, but something will be done. Both Home Office and Serco say they're committed to it, so there will need to be boosters or something put in. But that has been a problem for years, and now it's obvious because it's an expert's come in and done it. And you combine that with, there have been complaints about, and this is talking about legal aid because that's all we can see, some of the legal aid firms not having interpreters available, and also a significant problem, I think, and we didn't notice it until recently, was that for the initial meetings, the lawyers would come in, which I think is really important, particularly for vulnerable men, English not first language. Understandably, that stopped with COVID, but what also fell away was giving men fixed time appointments. So a man doesn't know when he's going to get his call, it will be tomorrow, but you combine that with a bad mobile phone signal. And so that's a very significant problem. So I've spoken about others. I mean, for ourselves, we have to, we need to get the annual report out. We have to do more, I've already acknowledged, on visibility, access, raising it. We need to continue the work with GDWG. I'd say they're probably the main things, yeah.
Thank you, Ms Molly. That's the only last question I had for you. The Chair may, however, have questions for you.
Thank you, Miss Molyneux. I do just have one question. I don't know whether you will have heard that I asked Mr Singh Buri a similar question when he gave evidence to the inquiry yesterday. It relates to some of the evidence that we've heard earlier in the hearings about the comfort that seemed to be taken from the reporting of the IMB and HMIP, and feeling amongst G4S and Home Office staff that gave them a level of reassurance. I just wonder if you have any observations about, you've talked about the remit of the IMB and what your role is about, and perhaps what the expectations can be on your members. I'm just interested if you have any observations, either from your own experience or anything from the evidence that you've heard.
Well, I have to say I was surprised at some of the Home Office, microphone, some of the Home Office evidence I've heard at the extent or at the reliance on the IMB. They have compliance teams. That is what compliance should be doing. We don't even see the contract. We don't need to see it because we're looking, even if the contract provides something, if we're not satisfied with the outcomes for detained men. So I do not think that is the IMB role. To be checking whether a supplier is complying with the contract or the laws or whatever. I think we do, as we said at the beginning, treatment conditions, administration. Now, sometimes monitor under the detention centre rules and report on it. But I am really surprised if people putting and should not be putting that much reliance on what IMB or HMIP does. Our roles, that is not our role to do that. That is not our remit, I don't believe. Yeah.
Thank you, that's very helpful. I don't have any other questions for you. Thank you very much for coming to give evidence today. It's been important to hear from you. I appreciate it.
Thank you.
Thank you.
Chair, next we have the evidence of D1914 that's going to be read in by Mr. Lee in a moment, but can I just suggest we take a 2-minute, you can rise for 2 minutes and we'll just swap around.
Of course.
Thank you.
Thank you.
Thank you, Ms. Bowley. Thank you. Ms. Townsend, thank you.
Good afternoon, Chair. We'll now be hearing from Mr. Lee, who's going to do the reading and summary for
Thank you.
D1914. Thank you.
Thank you, Mr. Lee.
Thank you, Chair. In the usual way, part of the statement will be read verbatim and some has been agreed to be summarised.
Thank you.
It begins with the usual statement of truth. The statement by D1914 is dated the 23rd of September 2021 and begins with a statement of his name and stating that he's a Romanian national. So I prepared this statement with the help of my representatives at Duncan Lewis Solicitors over 2 in-person appointments and a number of telephone appointments. I was homeless during the period I was giving evidence, including a period of rough sleeping. This made attending appointments regularly very difficult for me. My health issues, described in detail below, also made attending and speaking at appointments challenging for me. I find the sessions very tiring, and my persistent cough, linked to my COPD, makes speaking for long periods of time hard. I also find remembering my experiences at Brook House, especially my attempted suicide, very distressing. I arrived as an EU citizen in the United Kingdom in 2009. Until September 2019, I had a long-term partner in the UK. I was also in regular contact with my ex-wife and 2 children who live in Romania. I have suffered from serious ill health due to a heart condition since 2016. While in detention, the Home Office issued a deportation order on the 11th of April 2017 on the basis of my convictions abroad. I have not been convicted of any crimes in the UK. I successfully appealed this deportation order, confirmed in a letter from the Home Office on the 13th of June 2018. A person who would otherwise be entitled to reside under the Immigration European Economic Area Regulations 2006 may be removed from the United Kingdom if the Secretary of State decides that the person removed was justified on the grounds of public policy or public security in accordance with Regulation 21 of those regulations. The Secretary of State has given consideration to your successful appeal against deportation and has decided to take no further action on this occasion. So moving forward to paragraph 8. I was released from detention on the 8th of August 2017 following the completion of a Rule 35(1) report by the IRC Healthcare GP, almost 3 weeks earlier on the 17th of July 2017. It was my understanding at the time that the Home Office only released me because I had my heart surgery booked in for the 17th of August 2017, which had been known from the outset of my detention. The report found that I was a level 3 adult at risk as a result of my heart condition. It expressed concerns that continued detention could have a detrimental effect on my health, in particular that the stress related to detention could trigger another cardiac event. Nobody has ever explained to me why I had to be detained for almost 4 months before the GP at Brook House issued a report that detention could worsen my heart condition. This should have been known on the basis of the paperwork available to the Home Office and Healthcare from the outset. My experience at Brook House was very stressful for me. I was admitted to hospital 3 times during my detention as a result of my physical ill health. D1914 then goes on to summarise some of the incidents in detention, including on the 27th of May 2017. He summarises the history of his health issues, including coronary disease, palpitations in September 2016, and a heart attack in November 2016. He was deemed unfit for work from September 2016 until at least April 2017. And picking up the statement, again, Chair, at paragraph 28. Before I was detained, my partner at the time was looking after me due to my ill health. For example, she would do the cooking for me, washing and cleaning, because my heart condition prevented me from doing these things. She looked after me when I was in hospital too, and attended medical appointments to act as an interpreter. I needed her help with these everyday tasks because of my chest pains. At paragraph 29 of the statement, he explains that he continues to suffer from severe ill health. Again, picking the witness statement up at paragraph 30. I first travelled to the UK on the 1st of April 2009. Prior to this, I'd been living with my family in Italy. We'd moved from Romania to Italy in 2007, and after briefly returning to Romania, I went to the UK. The reason I came to the UK was to look for work. I worked in a car wash for just over 2 years after my arrival in the UK. Then I worked in the construction industry for around 5 years. moving to paragraph 34. My partner and I were together until September 2019 when our relationship broke down. Our relationship broke down partly as a result of my detention in Brook House, which placed an enormous strain on our relationship due to the stress of detention. My partner used to visit me regularly during my detention in Brook House, almost weekly. Detention placed a huge financial burden on us as we were paying lawyers privately to do my bail applications for me. My partner was herself placed in immigration detention and subsequently removed from the country. My children used to visit my partner and I every year during the school holidays for 2 months. We all used to get on very well as a family. Paragraph 37, he explains the background to extradition proceedings. And then moving forward to paragraph 45. I won my court case on appeal in 2016 against my extradition. The court found that given the previous discharge of the European arrest warrant, the lapse of time, the minor nature of my offences, and the circumstances of the former discharge of the warrant, extradition would be a disproportionate interference in my family life at the time. The judge recognised the huge impact the proceedings had had on me and my family, putting my life on hold during proceedings, sending my children back to Romania instead of putting them in school here, delaying undergoing IVF treatment, and needing to report daily to the police and being on a tag for curfew. At paragraphs 46 to 56, D1914 describes the events leading up to his detention, and at paragraphs 56 to 60, he sets out the decisions to detain him. The Home Office recommendation was as follows. It's back to the statement at paragraph 58. The recommendation stated, inter alia, subject also feigned illness when detained, claiming that he was having pains in his chest. He later changed his mind, which leads us to believe that he's using his illness to evade removal. He has his medication in his possession, so this can be controlled in the IRC. I therefore recommend detention to continue. And then at paragraphs 61 to 72, D1914 describes the induction process. And at paragraph 73, it says, I saw the IRC doctor, Dr. Chowdhury, the following morning after my arrival at Brook House on the 30th of March 2017. I did not have an interpreter at this meeting or any meetings with the medical professionals in Brook House. In fact, I never had an interpreter at any meetings with the Home Office or immigration officers at the centre. At paragraph 74 to 81, he describes initial medical appointments, how he did not have an interpreter, and how Dr. Chowdhury deemed him fit to fly and to be detained. He describes how an appointment with Dr. Chowdhury resulted in him being taken out of the room like he was a dog, and that negatively impacted his future relationship with Dr. Chowdhury. Back to the witness statement, Chair, at paragraph 82. I understand that on the 5th of April 2017, the Home Office wrote to the IRC healthcare team noting my heart condition and medication and asking, quote, please could you give us your professional opinion if he remains suitable for detention? In addition, and for removal purposes, could you please give us your professional opinion if he is fit to fly? Close quotes. I understand Dr. Chowdhury responded the same day, stating, quote, there is nothing we have noted at present contraindicating his suitability for detention or fitness to fly, close quotes. I find this response to be highly alarming. My heart condition was serious, and I did not believe I was fit to be detained or to be forcibly removed to Romania. I could not believe that Dr. Chowdhury did not provide any more information to the Home Office. Even if he thought I was fit to be detained or removed, I thought he should have at least tried to explain my heart condition to the Home Office and any possible risks and any way of minimising the risks to me. However, he did not even mention that I have a heart condition. On the 11th of April 2017, the Home Office provided me with a deportation decision dated the 10th of April 2017. I did not have an interpreter present when they provided me with this decision, meaning I could not fully understand everything that I was told. He then describes what followed, including being placed on an ACDT on the 12th of April. Back to the statement at paragraph 93. I've seen the letter which Dr. Uzerali wrote on the 12th of April 2017, apparently in response to another query from the Home Office as to whether I remained fit for detention. The doctor provided a one-line response. The above detainee remains fit to fly and fit for detention. As above, I am shocked by this brief response, which does not set out my heart condition or set out how detention could be suitable, despite the clear stress it was placing on me and the impact this could have on my heart. On the same day as this appointment, I wrote a letter to G4S complaining about Dr. Chowdhury. A Romanian friend in detention helped me to write the letter in English, which stated, quotes, I want to inform and complain about the doctor in IRC Brook House. He's very rude and bullying and humiliating me. I'm very sick. I have heart problems since the 20th of September. I have been through several heart attacks and 2 operations in Harefield on 2 months, and the doctor ignored me, and I'm feeling very distressed and upset. Now please help me, because I have need of an operation. I want to have my rights. Please, I beg for your help, and thanks for your attention. Thanks. At paragraphs 95 to 103, he describes medical treatment leading up to and including his first hospitalisation for his heart condition while he was detained. Back to the statement at paragraph 104. After my first hospital admission, my solicitors wrote to the Home Office on the 19th of April 2017 on the understanding that I'd had a heart attack and requesting that I should be released as I was not fit to be detained. They alerted the Home Office to the anxiety and stress that this incident had put on me and argued that detention was clearly not suitable for me as I could not manage in the conditions of the centre. At paragraphs 105 to 106, he summarises the contents of that letter. And at paragraph 107, he describes how on return to detention from hospital, he was seen by Dr. Chowdhury. He walked out of the consulting room telling Dr. Chowdhury, "You are a shit doctor." Dr. Chowdhury wrote to the Home Office after this meeting, stating that D1914 was fit to travel and fit to be detained. Back chair to the statement at paragraph 108. I do not feel I was fit to be in detention or to be removed at this point in time, and I do not know how Dr. Chowdhury could conclude that I was. I had undergone a heart operation twice before my detention and had been admitted to hospital the day previously due to chest pains. How could I be safe to be detained or to travel? I felt very upset at Dr. Chowdhury's assessment. He kept saying I did not have a health problem or conditions that would prevent my safe travel. This is why I said he was a shit doctor. I thought he was very bad at his job and was not looking after the best interests of my health as his patient. I did not intend it to be threatening at all. I was just really frustrated. Moving on to paragraph 110. On the 21st of April 2017, the Home Office responded to the 2 letters from my solicitor about the unsuitability of my detention, stating that they were aware of my medical condition, that I was receiving the appropriate medical attention for my health condition, and that the medical staff had declared me fit for detention. I did not feel my health complaints were being taken seriously by Dr. Chowdhury. I did not think the Home Office was taking appropriate measures to prevent me being hospitalised again, as my solicitors had argued they should. As I was still living in the very stressful conditions of the detention centre, without access to specialist healthcare. I was also suffering from worse symptoms of chest pain whilst in detention. I believe the stressful conditions of the centre, combined with the poor medical treatment I received, is why I was subsequently hospitalised another 3 times, in 2 cases due to my physical ill health and in 1 case due to my mental health. After my first hospitalisation, I continued to experience chest pain and lightheadedness. The pain in my chest was stabbing. It was very uncomfortable. I felt all the time like I did not have enough air, like I could not breathe. I found the detention environment stressful, with long periods in lockdown, lots of noise and smells, not much air, many detainees taking drugs and falling ill, and poor access to healthcare. From my entrance into Brook House, and especially as my symptoms worsened throughout detention, I relied heavily on my cellmate, who did the cleaning of the cell for me, helped me to get food, and also massaged my back when I had pain. Without his help, it would have been very difficult for me to manage. At paragraphs 113 to 129, he describes numerous visits to the detention healthcare, being hospitalised a second time for his heart condition on the 16th of May 2017, and summarises some of the documentation. Back to the statement at paragraph 130. One of the most disturbing and distressing events during my time at Brook House was when one of the officers used force to move me to E-Wing on the 27th of May 2017 in preparation for my planned removal the day after, despite my known heart problems, which can be exacerbated by stress. My legal representatives have shown me a document which records officers tried to negotiate extensively with me to get me to go to E-Wing during the day on the 27th of May. The officers did talk to me. They asked me to go to E-Wing to prepare for my removal to Romania. I said I did not want to. It was a short conversation. I disagree that they negotiated extensively with me. D1914, then up to paragraph 137, describes the footage and the transcripts that have already been seen by the inquiry and his reaction to it. At paragraph 138, so I cannot believe what officers said before the incident, including, quotes, "If he dies, he dies. I have a family. At the time I was with my partner, and I have 2 children with my former wife. If I died, it would be terrible for them. These people don't seem to care about the impact that my death would have on my loved ones, that they would have been distressed. They also called me a cunt and a dick. They saw me as subhuman, as a dog." From the transcripts, I can also see that officers diminished and mocked my health condition. Quotes, "collapse" or "pretends to collapse." I also find this hard to believe or understand. The officers knew about my health condition and knew it was not fake. Paragraph 141. I've also read the comments by an officer that they saw the letter from the doctor confirming that I was fit to fly, and that officers could use reasonable force against me as protection if anything happened to me. I find that very frightening, but it also confirms my experience in detention that the healthcare staff did not care about me at all. On the 27th of May 2017, I was in my room, sat on my bed. It was late in the evening, perhaps around 9 or 10 p.m. I remember it was dark. Suddenly, around 8 or 9 officers rushed into my room at the same time. It was very frightening. I was sat on my bed, and all of a sudden, all of these men appeared in their CNR kit in my room, rushing towards me. I had no idea what was going on. I was very shocked. I felt like my life was in danger. I fell to the bed in shock. I was worried that I might be about to have a heart attack, as I felt sharp chest pain. When I did this, the officers paused the use of force, and 2 nurses checked me. They took my blood pressure and oxygen levels. Whilst the nurses were making their observations, I told officers about my heart problems. I also asked to call my partner, as I was scared. I wanted to let her know what was happening. At paragraphs 147 to 154, D1914 describes the use of force incident which the inquiry has seen. He says at paragraph 151, "It felt like they were climbing all over me, on my arms, my back, on my head. I was shouting and howling in pain. I was struggling to breathe. I thought I might be dying. The pain in my chest was very severe. At that moment, I felt I was looking at death." It says at paragraph 153, "I've reviewed the accounts provided by the officers. I disagree with the claims that I intentionally dropped my weight to the floor. I fell to the floor in shock and in pain. I did not feel able to stand up at that point due to my chest pain. I felt completely weak. It's not true that I was resistant and non-compliant, and that I resisted against the officers. I was sick and scared and was worried that I might have another heart attack. The reports provided by officers also fail to accurately describe the force they used to get me into handcuffs. Paragraph 155. When I arrived in the isolation room in E-Wing, one of the officers, a manager, told me to take my clothes off for a strip search. He threatened that the officers would do this for me if I was not compliant. They took the handcuffs off and I had to take off my clothes and put on plastic underwear for a search. Whilst I was stood in the room in E-Wing in this underwear, the officers treated me like I was an animal. My legal representative asked if they were conducting a search. I cannot recall being searched, but I can recall being treated very roughly. It was humiliating. I had no clothes on, I was confused and in pain. I was in an isolation room and I felt that they were abusing me. At that moment, I thought that I would rather die than go on like this. After this, I was left in a room in E-Wing. Being in isolation made me feel much worse. I was confined. I could not see people. I did not have my phone, which meant I could not call my partner to tell her what was going on. She'd organised a solicitor for me. I could not call her or my solicitor. This was very distressing. I asked for my phone and was eventually provided it. I said that I wanted to complain about the officers' use of force during this incident. I had no idea at the time about how the officers mocked me, joked about hurting me, and had no regard to whether I died or not. The officers did not respond when I said I wanted to complain. I spent the night in isolation. I was finally able to call my partner and my lawyer to seek advice. I was scared about what would happen to me. I felt that I might die on the plane. At paragraphs 159 to 160, he describes being put on Rule 40 and that it and the force used was entirely unnecessary. Paragraph 161. I understand that Dr. Uzerali had determined in a letter dated the 27th of May 2021 that the officers could use force against me and that I was, quotes, fit to fly and fit for detention, close quotes. The letter concludes that, quotes, I am happy for reasonable force to be used, brackets C and R, close brackets, in order to facilitate the removal, close quotes. The letter from Dr. Uzerali did not set out anything about my heart conditions or what steps officers or escorts might need to take to reduce any risks. I've seen email correspondence within the Home Office on the 27th of May 2017 at 13:15 hours from the Deputy Immigration Manager, which states, quotes, G4S to have doctor to see D1914 today to confirm he is fit to fly and fit to be restrained if required. I will update after he's seen doctor, close quotes. A further email was sent by the Deputy Immigration Manager at 15:03, which states, quotes, FYI, D1914 has been seen by a doctor who has confirmed in writing that he is fit to fly and to be detained, close quotes. Despite this, the medical records show that I did not see Dr. Uzerali that day, and I had not seen him for at least a week prior. I do not know how he was able to make an assessment of my fitness to fly, to be detained or restrained, without having assessed me, particularly given my significant heart problem. At paragraphs 162 to 164, he gives further details of the subsequent use of force, and at paragraphs 165 to 174, he describes the Home Office attempt to remove him, how he was put in a straitjacket, and how he was not removed, in fact, on grounds of his heart condition. Back to the statement at paragraph 175. When I got back to Brook House, I was so relieved to be back. I understand, however, that a lot of officers were annoyed that I'd been returned to Brook House and not removed. I've seen at 33:50 minutes of the Panorama documentary, Callum Tully states, quotes, how's he back here? Close quotes. A male officer says, apparently he got on the plane and claimed to have a heart attack. A female officer, brackets putting on a voice, understood to be Gayatri Mehra, see V20170528000100 clip 2. Oh, I have a heart thing. I cannot go. And the pilot fucking took him out. Another male officer, understood to be Sean Sayers, CV 201 705 28000 100 clip 2, quotes, brought him back earlier. It's a fucking joke, innit? All that effort and hard work everyone put in. Another officer, it's fucking wrong, innit? Don't make any sense. At paragraphs 176 to 178, he states that he complained but never heard back. Paragraph 179, on the 28th of May, my partner visited me. She was shocked when she saw the bruising on my wrists. And then at paragraph 182, I have seen the transcript V2017052800011, where on the 28th of May 2017, Dan Lake calls me a nonce and an attempted murderer. The transcript shows that Dan Lake is laughing when he says this. The transcript shows that Dan Lake is laughing when he says, quotes, he doesn't rape kids, he kills them, close quotes. I'm also aware of the transcript V2017052800006 from the same day, where Callum Tully and Jan Pascali discuss completing a report. Callum Tully states, quotes, I didn't really have to write much, did I? I just took control of his head, close quotes. Jan Pascali replies, yeah, when Callum states, and used the minimum amount of force required. Jan Pascali responds, that's what we do. I'm worried that this shows officers were discussing what to put in the use of force reports to make sure they matched each other. I also find it concerning that officers would use such language about it. I've also been shown a later BBC transcript from the 9th of June 2017 by my solicitors, in which DCM Steve Loughton uses racist language, calling me a traveller. That's V2017060900004. It's difficult to find the words to describe my response to these remarks. They are shocking. That said, it was commonplace in my experience of detention for officers to use ugly words about detainees. I cannot recall the precise words they used, but I know they used to call me names to my face. On the 5th of June 2017, the Home Office reset removal directions for the 12th of June 2017. However, on the 7th of June 2017, Upper Tribunal Judge Smith made an order restraining my removal before my application for a judicial review had been heard. My solicitors subsequently wrote a letter to the Home Office on the 8th of June 2017 requesting that I be released, as I had obtained a court order staying my removal pending a decision of permission for a judicial review. The Home Office once again refused to release me, despite my 2 hospital admissions, my mental health issues, the recent failed removal, and the court order. They stated that there was no evidence to indicate my chest pains were as a result of detention rather than my underlying health condition, and stated I would be receiving appropriate medical treatment. However, I believe my underlying health condition was being exacerbated by the stress and anxiety of detention, and in particular the attempted removal. This was the conclusion of the Rule 35.1 report, which eventually led to my release. I do not understand why the Home Office did not conduct a Rule 35 assessment in light of the receipt of this letter from my solicitors. Paragraph 187. On the 5th of July 2017, I had a bail hearing where the judge refused to grant me bail. This was particularly upsetting as I feel that the judge did not have all the correct information before them about my upcoming medical appointment and the impact of detention on my health. I'd been in detention by this point for almost 4 months. I was unwell when I entered detention and I was feeling a lot worse. It was devastating to be refused. Paragraph 190. The judge had refused me bail and I was also very ill. At this point, I no longer wanted to live. I had never tried to harm myself before at Brook House. My experiences there are what drove me to try... Sorry, I'll read that again, Chair. I'd never tried to harm myself before Brook House. My experiences there are what drove me to try to take my own life. After the bell hearing, I found a razor and cut myself on my arms and neck. I also took 57 tablets from my various prescription medication. I did this because I wanted to die. I could not see a way out. Nurses came to my room, bandaged my wounds and called an ambulance. The healthcare entry by Nurse Carol Reed Bishop confirms, quotes, call to E-Wing response call. Nurse Skit, Nicola and myself in attendance. Cuts to both arms and around neck. Taken all his I/P meds. Called for ambulance. Dressed wounds. At paragraph 194. I thought I would die when I attempted suicide. I wanted to die, and that was fully my intention at the time. I lost so much blood, and I felt very sick after swallowing so many tablets. I've seen the reaction of staff members to my suicide attempt and the aftermath, which reflects how serious it was and how I was very close to dying. I've been shown a concern and keep safe form in which DCM Chris Donnelly, in which he ticks a box to confirm that the incidents were a, quote, suicide attempt or statement of intent to kill. I understand Callum Tully's handwritten diary note from the same day also states, I was told by a member of staff that a detainee had prolifically self-harmed yesterday. I saw the blood-soaked room that it left. I learnt in the late afternoon it was D1914 who self-harmed after his bail was refused. D1914 showed me his cuts to his neck and arms. I found them to be highly disturbing. I required a number of stitches for my wounds, and I still have scars on my neck and my arms. At paragraphs 195 to 197, he describes the response to this suicide attempt, including DCOs mocking him. At paragraphs 198 to 209, he describes the return to Brook House and the failure by Dr. Chowdhury to complete a Rule 35-2 report and the build-up to his fourth hospitalisation on the 10th of July. Back to the statement at paragraph 210. 3 days after my fourth hospitalisation, on the 13th of July 2017, I had a meeting with Dr. Chowdhury about my health problems. I said the same things I had said throughout detention, that I was too sick to be detained, that I had serious heart problems, and that detention was bad for my health. Finally, the doctor seemed to agree with me, and he wrote to the Home Office saying that detention was making me more sick, both physically and mentally. According to Home Office records, a Part C was received, stating, quote, D1914 has multiple health issues, which, although initially stable, are now at risk of worsening due to his detention. He has been to healthcare increasingly more due to his cardiac symptoms, and I feel he is at risk of further cardiac issues should he have prolonged time in detention. My lawyers have explained that numerous documents called Part Cs were sent to the Home Office during my time in detention. However, except the Part C of 13th of July, which indicated I was not fit to be detained, I do not think the Home Office ever responded to these, as nothing seemed to change, and I continued to be detained. HOM 007159 shows that Part Cs were issued on the 11th of April, 19th of April, 27th of May, 28th of May, 3rd of June, 5th of July, 6th of July, 7th of July, and the 13th of July. I told a Home Office official, Vanessa Smith, during an interview on the 15th of July 2017 that I wanted to be released because of my medical issues and that I was hurting myself whilst in detention. The Home Office Security Information Report states, quote, during the interview, the detainee stated that he wished to be released ASAP. He was upset and said that he had been harming himself and cutting his hands, which shows on his hand, brackets marks, close brackets. He said if he is not released, he will be doing something to himself. I had another appointment with the doctor on the 17th of July 2017, where he completed a Rule 35-1 report for me. He asked me about my history of heart problems and the symptoms I was experiencing. Thereafter, the content of that particular medical report is then set out. At paragraph 214, picking that paragraph up halfway down, I do not know why the doctors basically wanted to wait until I had actually suffered harm from detention before informing the Home Office of the risks of detaining someone like me with such serious heart conditions. I do not understand why this report was not issued by them any earlier, or why Dr. Uzerali and Dr. Chowdhury sent repeated letters to the Home Office saying I was fit to be detained, fit to be removed, and fit to have force used against me by officers. I had my Rule 35 appointment on the 17th of July 2017, and the medical records state on the same day that Dr. Uzerali completed it that, quote, 17th of July 2017, 13:26, history / Rule 35 done, medical concerns, clinical letter to D1914. I do not understand why it took the Home Office a further 3 weeks to release me following the production of the Rule 35-1 report. The weeks between my Rule 35-1 report appointment and my release were hugely stressful. I was constantly worrying that I might have another heart attack. He then sets out the detail of those stresses at paragraphs 219 to 225, picking the witness statement back up at paragraph 226. As a result of the report, the Home Office decided on the 1st of August 2017 to release me. In an email from Paul Benson to Daniel Dyer, it is stated that, quote, the main reason for the release referral is that a Rule 35 report indicates that his health, he has a serious heart condition, is being impacted by his continued detention, close quotes. I do not understand why this was not a reason to release me at the outset of my detention when my health conditions were known or ought to have been known. Despite this decision being made on the 1st of August 2017, I was not released until the 8th of August 2017. He then addresses the physical environment, drugs and alcohol, and the continued impact of his detention through to paragraph 242. And at paragraph 243, Chair, he says, I successfully challenged my deportation on the 30th of May 2018, as described in paragraph 6, First Tier Tribunal Judge Buckwell found, quotes, in this appeal, I must take into account the findings and the conclusions of Lord Justice McComb and Mr. Justice Ouseley in the High Court judgment of D1914 above. The High Court concluded that extradition to Romania would be a disproportionate interference with the Article 8 ECHR rights of the appellant. In all the circumstances, it would be incorrect for the proposed deportation of the appellant to be found other than in parallel to the findings with respect to extradition. Notwithstanding the failure of the appellant to attend the appeal hearing, the reality is that Ms. Lambert was not able to put forward any reasons why this tribunal should take a different approach from the conclusions reached by the High Court in relation to the appellant in terms of his human rights in relation to Article 8 of the ECHR. For the reasons stated above, it is found that the deportation of the appellant would constitute a disproportionate interference with his engaged Article 8 ECHR rights. Accordingly, the respondent's decision amounts to a breach of her duties under Section 6.1 of the 1998 Act, and the respondent cannot succeed in discharging her burden with respect to deportation under the EEA regulations or the 1971 Act. After this, the Home Office removed my tag, which I'd been on since release. My time in detention in Brook House, IRC, broke my life. I cannot believe the state I've been reduced to. Brook House had a lasting impact on my mental health. It made my mood very low. It also was a place that made me very angry, very agitated. I found it difficult to recover from the damage Brook House did to my mental health. I feel low, often. What happened to me in Brook House, the abuse I suffered there, often comes into my mind. These memories make me feel sad and unwell. My life fell apart after my release. I feel like Brook House broke my life. As described in paragraph 34, in the years following my release, my relationship with my partner broke down, in part because of the stress and strain my detention had placed on our relationship. I lost contact with my children and my ex-wife. Initially, I'd been living in redacted with my partner, but after we broke up, I stayed with my cousin. For a while, I then moved, again it's been redacted, but following a fire in the apartment block, I moved to a local authority accommodation. I could not work. I was not permitted to do so, and I was reliant on the kindness and pity of friends to provide me with food and the money I needed to survive. In July 2021, I became street homeless. Following a period of extreme cold weather in November 2021, I was provided with accommodation by St Mungo's. I feel like if people who knew me before Brook House could see me now, they would be shocked. I am totally changed, physically and mentally. My legal representative asked me what outcome I would like to see from the inquiry. Above all, I would like to see the healthcare staff, the nurses and the medics who treated me so badly brought to account. I also want to ensure that no one experiences what I experienced in Brook House ever again. And at paragraphs 255 to the end of the statement, Chair, he answers the various Rule 9 questions that the inquiry put to him, and the statement concludes with a statement of truth.
Thank you very much, Mr. Lee, and thank you very much to D1914 for his evidence. Thank you. Ms Townsend.
Chair, we have a list of witness statements which we seek your permission to adduce. The list of statements and URNs on these statements themselves will be published on the website. These include, firstly, statements from some DCOs and DCMs, in particular James Begg, Bonnie Spark, Graham Matchett, Kaz Dance-Jones, Mark Earle and Nathan Harris. Secondly, 4 healthcare staff, Michael Wells, James Newlands, Dr Belder and Dahlia Dowd. Thirdly, 4 G4S managers, John Kench, Ashley Almanza, Paul Kempster and Martin Kenyon. And lastly, 3 witnesses from Medical Justice, as Emma Ginn, Professor Katona and Dr Patterson. We also seek your permission to adduce a number of additional statements in due course. Additionally, Chair, the inquiry has also produced a list of documents relevant to the evidence of witnesses who gave oral evidence in weeks 1 and 2. Extracts of some of these documents have already been adduced. However, it is not necessary to ask the witness about each of the documents or every page of them when they came to give evidence. We do consider it is necessary to adduce these documents in full. The list was circulated to all core participants last week, and with your permission, Chair, the list of documents and URNs and the documents themselves will be adduced and will be published on the inquiry's website as soon as possible. Similar lists are being prepared for subsequent weeks, and we will seek your permission to publish those lists and the documents themselves at an opportune moment next week.
Thank you very much. I'm very happy to agree to all of that. Thank you, Ms
Thank you very much,
Townsend.
Chair. Chair will resume at 10 o'clock on Monday with the evidence of Dr Hard.
Thank you very much.